Boathouse Marine and Power Sports versus Aaron Shadick.
Good afternoon, Judge Paul Slough on behalf of Boathouse Marine and Power Sports.
Good afternoon, Judge Jeff Klug on behalf of Defendant Aaron Shadick.
Looks like we've got some submissions from both sides. Since we were here last, it appears that the defendant has come up with a potential expert witness. It looks to me like it would be necessary for a hearing on that. Mr. Slough, would you agree with that analysis?
Well, I don't, Judge. I did submit a reply. I don't know if you've had a chance to review that.
I have not seen that.
Yeah. If I could just give me a minute and I can just run through my arguments.
Go ahead.
Yeah. So specifically with regard to the reply, what the response attempts to do is rely on an email from an individual, Mr. Arlt, who works evidently at some local marina. The email is not in an affidavit format. This is a summary disposition motion. The court rule is very clear. The court can only look at admissible evidence. So it's got to be deposition transcripts. It's got to be affidavits. It's got to be sworn testimony of some sort. Even if the court were to accept that email and look beyond the hearsay nature of it and the fact that it's not in the proper format, Mr. Arlt hasn't provided any credentials. So we don't know in terms of his expertise, what his experience is, what his training is, and there's no foundation for his opinion. I mean, he hasn't articulated what he looked at or how he arrived at the opinion, and whether he looked at photos or if he was just relying on what was told to him by counsel. So in light of that, his opinion is not admissible to oppose a summary disposition motion. They've had 4 to 5 months here. If they have an expert to support these alleged defect claims and their counterclaims, they should have gotten an affidavit from their expert. This last minute email is simply insufficient. There's also an argument raised about us not giving the maintenance history on the jet ski. That's inaccurate. We attached another copy to the reply. It was attached to our responses and discovery. The reality is we did produce that maintenance history, and there's absolutely nothing in that maintenance history to suggest any defect to this unit or explain how 2 rocks would have gotten jammed in the impeller. The other thing the response tries to do is create an issue of fact around who delivered the jet ski, but that's not a material fact. The material facts are very straightforward. The defendant signed the contract. The jet ski was working. It was working when it was delivered and entrusted to her care, and then it stopped working while she had it, when her family was using it. In light of that, there's just no genuine issue of fact, and summary disposition should be granted. Thank you very much.
Thank you, Mr. Slough. Mr. Klug?
Your Honor, I would disagree with that. They have a high standard to prove on a motion for summary disposition. That is, there is no genuine issue as to any material fact. Here, there are genuine issues of material fact all over. You have, number one, you have plaintiff's attorney wouldn't admit it. He skated around it, but his client's affidavit is false. There's false statements in there pertaining to who delivered that jet ski. He signed that affidavit. So there's credibility witnesses, which are for the trier of fact, which would be a jury in this matter. Additionally, Exhibit 1 to their reply brief draws more inconsistencies, because on page 2, there's an arrow, and that is from the alleged damages that they're alleging my client caused. And it says, remove ski rope from impeller. So this is their own document. They're saying rocks, but they're saying it's a ski rope. Which one is it? Not only that, Your Honor, nobody witnessed them. Nobody, as stated in my response, they didn't witness Ms. Shadick driving it. Exhibit C to plaintiff's response are the defendant's, is plaintiff's answer to request for admissions, where the plaintiff admits that there has been damage to the jet ski in the past pertaining to the impeller and the housing. Yet, Exhibit 1 to their reply brief, Your Honor, they have all of these notes as to what was caused. There are nobody listed in there for damage to the impeller or housing. So there are inconsistencies all over, and we were here less than a month ago in front of you, Judge, on defendant's motion to compel, because they left out a lot of stuff in discovery, which we want to seek. We want to know who these other individuals were who.
Okay, Mr. Klug, Were you here last month?
I was not. My associate, I was out of the office last month.
I remember this case very well. I told him very clearly I didn't believe that discovery was necessary further because I couldn't see any way that the jet ski could be driven from Boathouse all the way across the lake to your client. But I'd be happy to have some evidence of that given to me. So that's what we were here for this time, was not discovery issues, but for you to submit some evidence to make a question of fact as to whether or not that jet ski could be driven all the way across the lake and dropped off for your client. That's all I want to hear about, because quite frankly, to me, that's the crux of the issue. So I'm not going to redo all of the last month's discovery stuff. If you guys can't talk to each other or you can't figure out what your case is doing, I'm sorry, but that's not my fault. So the issue was, is there a question of fact on whether or not the jet ski could be driven from Boathouse to your client, after which it was then damaged?
Okay. And
so
yes,
you've given a email, apparently, that says that you've got somebody, maybe we don't know who, or is it Qualifications? I'm just hearing from Mr. Slough, but that's where I want to go with this case. So that's where my question is. So Mr. Slough says you didn't submit an affidavit. Tell me about your witness. Why should I believe that there's a question of fact as to whether or not the jet ski could be driven across the lake?
Okay, Your Honor, Grover Alt, and it is exhibit I and J to Shadick's response. Those are emails from Grover Alt. He is an operations service manager at Coldwater Lake Marina. We have had discussions with him, and he has been servicing Sea-Doos jet skis for 17 years, 11 as a certified master Sea-Doo technician with annual recertifications. We provided him with the facts of this case. We provided him with the photos that the plaintiff provided to us, which are Exhibit I. He reviewed all of those and responded via email. He didn't sign an affidavit. I understand that, but he responded by email, and he will be a witness there for us, stating that, and it's quoted on page 8 of my response brief, defendant's response brief. It said, based on the photos, the damage couldn't have been caused by mechanical failure and only due to the knowledge of shallow spots as misuse. With that being said, the amount of damage I see on the trailing edge of the impeller could be an indicator that the rock had been in the stator veins for a while. The machine could have absolutely been delivered to the dock with the rocks lodged on the trailing edge of the impeller. That is what this witness will testify to, and he will be subpoenaed to come in if he doesn't come in voluntarily, because we've been communicating with him, Your Honor. That is somebody who we found who has knowledge of jet skis, who's reviewed the documents that the plaintiff provided to us in response. And that's where we go. And that one individual will be subpoenaed. Right now, he hasn't signed an affidavit, but that is the email that we got from him, Judge. And unfortunately, as you're aware, if somebody's not going to cooperate, I will issue a subpoena to him to force him to cooperate. But that was somebody we communicated with who is a certified master mechanic, and he reviewed this. And we're trying to talk to others, but because I'm trying to get other people to testify regarding it. But that is one person who testified that it could, who will testify. He can't change his testimony from that Sea-Doo could be driven with those two small rocks in the impeller.
Why isn't there not an affidavit to that effect?
After we were speaking with him, Judge, his employer did not want him to testify as an expert. He doesn't own the shop. He's a mechanic. So that is where I'm at, is I would have to have him subpoena coming in before he has stated that he has been asked for. He has been an expert, but he would be coming in. Our witness list isn't due yet, but he would definitely be a witness that we are going to subpoena and pay the proper fee for him to come in and testify as to what he's looked at and what his conclusions are and whether it meets the same as he stated in his email, which he represented to us. So that is right now the witness who's going to testify that, yes, it could be driven. I don't expect his testimony to change from that email.
So if I do allow discovery as to that witness, so you telling me you don't know whether or not he's going to comply with the subpoena because his employer won't let him?
I have the email right now, and if you want me to submit a follow-up brief, it was sent right before a response.
I need to know if this guy's going to testify to that.
Yes, that's what he would testify
Mr. Slough is entitled to do a deposition if he wants.
Yes.
If I may, Judge, I mean, this is highly irregular. If they haven't retained him as an expert, they can't subpoena him. He's not a fact witness. He hasn't seen anything. I mean, he's given an informal opinion by an email. He absolutely could change his testimony based on whatever facts are presented to him, which we don't know what exactly was presented to him. That's the problem. It's got to be in an affidavit. So again,
that's why we have affidavits, Mr. Klug, because
correct.
Experts don't have to testify if they don't want to. And how do I know this guy's an expert? Just because you work in a shop doesn't mean you're an expert.
Based off of his experience, Judge, of 17 years working at CDUs, 11 as a mechanic in CDUs, certified annual recertifications. This is what he stated in his emails. And he's looked at the pictures that the plaintiff provided through discovery, and that's what he based his opinion off of. And he stated that, yes, that CDU could be driven with those two small rocks in the impeller. And if Mr. Slough wants to take his deposition, he sure can. Yeah, I wasn't too happy at the 11th hour that he said his employer will not let him be an expert. After he already communicated, and we have communication emails with him that he would, and we gave him the exact photos that the plaintiff turned over in discovery. That's all we have is those photos that they turned over in discovery, Judge.
Okay, Mr. Klug, here's what I'm going to do. I'm going to give you an opportunity to get this witness into shape. Mr. Slough, how long do you need to depose him?
Judge, candidly, I don't want to take his deposition. It costs $1,500 to my client to hire a court reporter and take this guy's deposition. If the court is inclined to entertain this, then I would suggest just set it for trial. Let's just get him in there and let's get the testimony and get it over with. I mean, my client's now into this by about $6,500 in attorney fees over an $1,100 damage to a jet ski, which is exactly what I was concerned about when this case first came about. It's been nothing but motions and written discovery requests on and on and on. So it's just not practical to take a dep in this case. All
right. And I get the economic argument that you're making, and hopefully Mr. Klug understands it as well. Because if I find for one party or the other, attorney's fees, I'm sure, are going to be requested once this case is resolved. And it's going to be a huge bill. So I would think that the parties need to sit down and very seriously contemplate how to resolve this matter like adults, as opposed to just taking sides and hoping that your side wins. Mr. Klug, I'm not impressed so far. I'll have this matter set for a trial. Bring your witnesses in. We'll have the trial. We do this in front of a bench or in front of the jury.
Jury, Your Honor.
They demanded a jury, Judge, yes.
All right. Court will set the matter for a jury trial 1 week in advance. We'll do a settlement conference. "14 days in advance, I want jury instructions, and I do not want a set from each side. I want the attorneys to meet and to give me one combined set of jury instructions if there's any disagreement, we will resolve it at the last final settlement conference. But I'm not looking for, aside from jury instructions from both, that I have to go through and try to figure out which minor deviations you made. The attorneys will compile that. Witness and exhibit list, 14 days in advance. Any evidentiary issues noticed up and briefed 14 days in advance. And we'll hear all of those issues at the final settlement conference. Any questions, counsel?
No, Judge.
Just to be clear for the record, Judge, are you denying both of the motions?
Yes.
Do you want an order to that effect?
Yes, please. That's all for today. Thank you very much.
Thank you, Judge.